Hello friends, very good morning. Let us continue today with our chapter 2 Indian Contract Act 1872 Unit 5. Okay, so let's straight away go to the topic. What is the heading of the topic? What's the topic we have? Yes, it is breach of contract and its remedies. Just a second. Yeah. So it is breach of contract and its remedies. Yesterday I said one point, right? When the contract gets discharged by breach. Discharged by breach of contract. Exactly. Yeah. So let us learn about this word today. What is meant by breach? What's meant by breach? Breach means, yes, yesterday I said it, failure to perform. So, failure of a party to perform his or her obligation under a contract is called as breach. Now, let us understand what is meant by breach. First of all, it is failure of performance, failure to perform what is promised under the contract. Okay? Failure to perform whatever is promised under the contract, that's called as breach. Now the breach is of two types. Number one, actual breach. Number two, anticipatory breach. Okay. Now let us try to understand these two breaches with the help of a very simple example. Okay. What is the example? Suppose A promises to deliver 1000 bags of rice. 1000 bags of rice at rupees. Suppose let us make it 50,000. 50,000 by let us say by 10th of March. Okay. Did you get the question? A wants to deliver 1000 bags of rice at rupees 50,000 by 10th of March. Now, what is meant by breach? I said, what is the definition of the breach? Failure of performance. Failure to perform. Now, suppose A promised that he will deliver by 10th of March. Correct? Now what happens? There was 10th of March. 10th of March came, but on 10th of March, A did not deliver any kind of rice to B. A fails to perform his part of promise on 10th of March. A does not deliver any kind of rice to B on 10th of March. He is failing to perform. He is not performing his part of promise. Then it is called as actual breach. What is it now? It is actual breach. Are you clear? Are you clear? Okay. Now, let us come to the next point, anticipatory breach. Ma'am, what is meant by anticipatory breach? Anticipatory breach means, what happens here is, now before 10th of March, in a 10th of March bandila, before 10th of March, A, suppose the contract was made on suppose 3rd of March. So, on 5th of March only, on 5th of March or any date before 10th March, okay, A refuses that I will not deliver you the bags of rice before the due date only. The due date is on 10th of March. Before due date, A refuses to deliver the bags of rice to B. That's called anticipatory breach. So, before the due date, if the promiser fails to perform his part of promise, then is called as anticipatory breach. Okay. If on the due date they fail to perform, then it is called as actual breach. Are you clear with both? Okay. So, this is about, in both the cases, what happens to the contract? Contract is discharged. So, that is what we studied in the last class. Contract is discharged by breach. Now, quickly I am reading the examples as well as the definition part. Just go through with me the definition part and then move on. Just a second. Anticipatory breach, see, it's a breach of contract occurring before the time fixed for performance has arrived. So, before the time they are refusing to perform the contract. Now, he signifies that I will not do before the time for performance has arrived. It is called as anticipatory breach. He altogether says I will not deliver, it will not be possible by me before the due date itself, then it is called as anticipatory breach. It can happen in two ways. Number one, express, number two, implied. Correct? How is express? Clearly calling you and telling I will not deliver. And how it is possible that by conduct? By conduct, how is it possible? Suppose the same products, he said he will deliver it to B, correct? Now, he does not tell you anything, but on 5th of March, he sold those 1000 bags of rice to C. It means he had made a breach, same 1000 bags, what is required by B is been sold to C on 5th of March. Then it is called as anticipatory breach by conduct. He did not tell anything, but he clearly did not give any rice to B, but delivered it to C. Clear? It is by anticipatory breach. Artha aita? Enagta ide anta? Yeah. So, breach expressly agbodu by using of words either spoken or by written. Next one is by implied means. Okay na? You'll nodi. Examples quickly I am reading. Just go through the examples with me. A contracts with B on 15 July to supply 10 bales of cotton for a specified sum on 14th August. But on 30th July only B informs that he will not be able to supply the said cotton. 14th August was the due date, but on 30th July only B is telling I will not be able to supply to you. So, this is called as express rejection of the contract, and this is express anticipatory breach of contract. Okay. Now, one more. Where A agrees to sell his white horse to B for 50,000 on 10th of August. He sells the horse to C on 1st of August. So, it is again anticipatory breach, but by conduct. That is by implied means. Okay, clear? Now, what are the effects of anticipatory breach and what is the effect of actual breach? We will see one by one. Number one, what happens when there is an anticipatory breach? So, whenever it is an anticipatory breach, what are the effects? Number one, there are two effects actually. Now, in our above example, what will happen? Now, if A does not deliver, A is not delivering, correct? The 1000 bags of rice to B, A is failing to perform. So, what can happen is, now B, what can B do? If A is not delivering, what can the B do? B can cancel the contract immediately. Cancel the contract immediately and ask for compensation. Cancel the contract immediately and ask for compensation on 5th of March itself. On 5th of March only he can cancel, because on 5th of March he is telling no, I will not deliver. Correct? So, he can cancel the contract on 5th of March and ask for the compensation and sue for the damages. Next, number two, what he can do? In the 5th of March, let us wait till 10th of March. He can wait. What he can do? He can wait till 10th of March. Why is he waiting? In a due date bandila. On 5th of March is telling, see, it is not possible by me. I will not deliver the bags of rice to you. So, now B, what does B think? B is like, let us wait. Let us wait till 10th of March. By chance, if he changes his mind. Suppose he now makes a mind to deliver the bags of rice within 10th of March. So, let us give him time. So, he is keeping quiet. So, one thing what can happen? He can wait till 10th of March, hoping that the promiser may change the mind and deliver the goods. Promiser may change his mind and deliver the goods. That is the first thing. Second thing, what can happen? One more thing what can happen is, suppose between 5th of March and 10th of March. On 5th of March, he clearly said, I will not perform. But B did not cancel the contract. He waited. He waited till 10th of March. But suppose on 7th of March, a fire occurred. Fire occurs on 7th of March and whole of the bags of rice is destroyed. Whole of the bags of the rice is destroyed. Now tell me, what happens? Now tell me, what happens? Can Can B now cancel the contract and ask for damages? Can B cancel the contract and ask for the damages? Did you get the question first? Yeah? Did you understand? See what has happened? 5th of March, A clearly told I will not deliver the rice. But B did not cancel the contract immediately, waited till 10th of March. Yeah? Because this was the due date. Now, on 7th of March, a fire occurred in the A's factory and destroyed all of the rice on which the contract was formed. Okay? ಈಗ ರೈಸ್ ಎಲ್ಲ ಡಿಸ್ಟ್ರಾಯ್ ಆಗೋಯ್ತು. ಈಗ ಬಿ ಆ ಕಾಂಟ್ರಾಕ್ಟ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬೋದಾ, ಆರ್ ಹಿ ಕ್ಯಾನ್ ಆಸ್ಕ್ ಫಾರ್ ದ ಡ್ಯಾಮೇಜಸ್, ಬಿಕಾಸ್ ನೀನು ಆ 5th of Marchಗೆ ಹೇಳ್ಬಿಟ್ಟಿದೆಯಲ್ಲ ನಂಗೆ ರೈಸ್ ಕೊಡಲ್ಲ ಅಂತ. ನೌ ಯು ಗಿವ್ ದ ಡ್ಯಾಮೇಜಸ್ ಆರ್ ಕ್ಯಾನ್ಸಲ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್. ಕ್ಯಾನ್ ಹಿ ಡೂ ಸೊ? So here normally because he did not cancel the contract, what happened? If he told antandre you did not take the action immediately, correct? Now what happens is B cannot cancel the contract and cannot claim for the damages, because when subject matter gets destroyed the contract becomes void. The contract will become void and B will have no rights against it. Clear? But ade if B does not wait till 10th of March and on 5th of March avun cancel madbitre, he can claim for the compensation and he can claim the damages. Illi damages kellik barutte. 5th of March only if he cancels the contract he can claim for the damages. Okay? But if he waits till 10th of March and in between some unforeseen circumstances come, if the subject matter gets destroyed, then he cannot claim for the damages. Clear? But ade 10th of March tananu wait madidru, no fire occurred, nothing happened, then can B claim damages? Avag B damages kedlik barutta? Yes, he can. Okay? So on 10th of March, if no fire has occurred, nothing has happened, then B can cancel the contract at that point of time and claim for the damages. Are you clear? 3 circumstances are there. First thing, immediately, see I am summing up. Matte summarize ಮಾಡ್ತಾ ಇದೀನಿ. First one, what are the effects of anticipatory breach? Number 1, the promisee can cancel the contract immediately and claim for the damages. Second one, can wait till the due date. If at all promisee changes his mind. Okay, ಅವನು ಎದಕ್ಕೆ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ? ಏನಾದರೂ ಅವ್ನು ಮನ್ಸ್ ಚೇಂಜ್ ಮಾಡಿ ಆ ಕಾಂಟ್ರಾಕ್ಟ್ ಪರ್ಫಾರ್ಮ್ ಮಾಡಿಬಿಟ್ರೆ ಅಂತ. ಓಕೆ, ಬಟ್ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, but still if he does not perform, then he can cancel the contract on the due date and claim for the damages. Correct? But if he does not cancel and wait till the due date, and if there is any chances of destruction of the subject matter, then the contract will become void and B will not be able to claim the damages. Are you clear? See here, look here now. First, treat the contract rescinded and sue the other party for the damages. That's the first option he gets. Immediately ಏನು ಮಾಡಬೇಕು? Rescinded means cancel and sue the other party for damages immediately without waiting till the due date. That's the first option he has. Second option what he has, see this question can come. So that's why he may elect not to cancel and he will still take the contract as operative, hold the other party, wait for the time of performance and then hold the party responsible for consequences of non-performance. But it can give benefits if the contract is alive. The other party will also get the benefit. That is, first is guilty party if he does reconsideration. ಅವನು ಏನಾದರೂ reconsideration ಮಾಡಿದ್ರೆ, months ಏನಾದರೂ change ಮಾಡಿದ್ರೆ ಅಂತ ಅವನಿಗೆ benefit. But still he can also take the advantage of supervening impossibility which may have effect of discharging the contract. Ade ande if subject matter gets destroyed or any kind of supervening impossibility bandbittu antandre enagutte avaga the contract will become void and we will not be able to cancel and sue for the damages. Are we clear with the anticipatory breach? Yeah? Okay. Number 2. Now if there is actual breach, andre due date bantu, due date ಗೆ perform madilla, andre it is actual breach. If there is actual breach, what happens? Then see when on the scheduled date he is not performing, breaks the promise is said to have committed breach. The other party gets a right of action against the one who has refused to perform his promise. So he will get the right of actions. What are those rights? We will see one by one. Okay. So first, actual breach may be committed on at the time when the performance is due, during the performance of the contract, both. Like suppose if I said I will deliver on 10th of August and if I don't deliver on 10th of August, then it is called as time when the performance was due, I did not do it. During the performance antandre, actual breach occurs when during the performance one party fails or refuses to perform under it by express or implied act. Andre one party has already started doing but the other party is not ready to perform. Then it is called during the performance. Are we clear? Yeah? Chalo. I think I will sum up once more for you and then we will go. See, first thing what I said is, what is meant by breach? Breach means, yes, failure to perform what is promised in the contract. It is of two types. What are the two types we had? Actual, anticipatory. What is meant by actual breach? Actual breach means failure to perform on the due date. On the scheduled date. Okay, this is before the specified time you fail to perform or refuse to perform before specified time, before due date, before time. Okay, this is anticipatory breach. Now what are the effects? Here the other party gets all the rights to sue the other party. Here there are two things: cancel the contract immediately, immediate cancel, and claim for the damages, sue the party for the damages. Second one, wait till the due date, then cancel and claim for the damages. Third one, if they are waiting till the due date, in between that date, considering that there may be a chance of reconsideration by the other party, but the other party can also take the advantage of that wait by if supervening impossibility occurs. Enadru madhyadalli supervening impossibility bantu antandre the guilty party will be benefited. Okay, this is about breach, actual breach, anticipatory breach. Okay, many a times question has come, direct question, what are the effects of anticipatory breach, so for 2 marks or 3 marks. So this you can answer section 39. Okay na, clear? That is the effect of anticipatory breach. You can also quote one example. If you remember the example, quote the example as well. Okay, so moving on to the remedies. Andre breach antru agutte, ee remedies enu anta nodkobeku. Correct? Remedies antandre nam law, if other parties does not perform, then what remedies we have, what rights we have, that we are discussing. The suit for damages question comes many a times from this, so please listen to carefully and understand this. What's meant by suit for damages? The first remedy we have is suit for damages. Shall I? Yeah. According to section 73, the amount of compensation lays down the rules as to how the amount of compensation must be determined. Okay. So if there is a breach, the other party is entitled to receive compensation or loss or damage caused to him by the breach. Of course, no, if the contract is broken, whatever damage the other party has faced, whatever loss the other party has faced, that must be compensated. Okay, chalo. So compensation he can ask for what? First one, please remember, compensation can be claimed for any loss which naturally arises in the usual course of events. The compensation can be asked for any loss which is naturally occurring. Ad madilla andre avrige ashtu loss aagta ide. Okay, that you can ask. Second one, compensation can also be claimed for the damages which the party knew when they entered. ಪಾರ್ಟಿಗೆ ಮೊದಲಿಂದಾನೇ ಗೊತ್ತಿತ್ತು, ಇಫ್ ನೀವು ಇದು ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದರೆ ನನಗೆ ಇಷ್ಟು ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ, ಮೊದಲಿಂದನೂ ಡಿಸೈಡೆಡ್ ಇತ್ತು ಅಂತಂದರೆ ದಟ್ ಡ್ಯಾಮೇಜ್ ಯು ಕ್ಯಾನ್ ಕ್ಲೇಮ್. ಸೆಕೆಂಡ್ ಒನ್, ಥರ್ಡ್ ಒನ್, ಸ್ಪೆಷಲ್ ಡ್ಯಾಮೇಜ್ ಕ್ಯಾನ್ ಬಿ ಕ್ಲೇಮ್ಡ್. ನಿಮ್ಗೆ ಏನಾದರೂ ತುಂಬಾ ಸ್ಪೆಷಲ್ ಡ್ಯಾಮೇಜ್ ಏನು ಅದೆಲ್ಲ ಅಂತ ನಾನು ಮುಂದೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಬಟ್ ಸ್ಪೆಷಲ್ ಡ್ಯಾಮೇಜ್ ಕ್ಯಾನ್ ಆಲ್ಸೋ ಬಿ ಕ್ಲೇಮ್, ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಗಿವ್ ಪ್ರೀವಿಯಸ್ ನೋಟಿಸ್. ಓನ್ಲಿ ದೆನ್ ಯು ಕ್ಯಾನ್ ಕ್ಲೇಮ್ ಸ್ಪೆಷಲ್ ಡ್ಯಾಮೇಜ್. Number 4, you cannot ask compensation for the remote or indirect loss. Are you clear? First, you can take ordinary damages. Number 2, you can Also claim the special damages only if you give previous notice. Number 3, you cannot claim the compensation for remote or indirect loss. Remote ಅಂತಂದ್ರೆ ಏನು? ತುಂಬಾ ಚಿಕ್ಕ ಲಾಸಿಗೆ you cannot ask for compensation. Okay, are you clear? These are the 3 points which you should remember. Now let us see, ma'am, what is ordinary damage, what is special damage, that we will see now. Tumba damages ಇದೆ. Okay, let us learn about them. The law is actual fun, correct? What we can do, what we cannot do, you can apply all these things in your practical life as well. Yeah. Now, what is meant by ordinary damage? Ordinary damage antandre enu? Very simple. Ordinary damage andre which arises in the natural course of the business, the loss which is occurred to the party naturally. See, for any loss, damage or cost to him naturally arose in the usual course of things from the breach. Andre parties ig modlindane gottittu, if he does not perform, I will face this loss. That is only the ordinary damage. Okay, ordinary damage bantu one word barbeku enu, naturally arising, naturally occurring to the party. Okay, so yes, so the aggrieved party is entitled to the compensation. Aggrieved party ಗೆ ಅಷ್ಟೇ damages ಕೊಡಬೇಕು, ಅದರ್ ಪಾರ್ಟಿಗಲ್ಲ. ಓಕೆನಾ? ಮತ್ತೆ ನೀವು ಯಾರು ಬ್ರೀಚ್ ಮಾಡಿರ್ತಾರೆ ಅವ್ರಿಗೆ ಹೋಗಿ ನಾನು ಡ್ಯಾಮೇಜ್ ಕೊಡ್ತಿದ್ದೀರಿ. ಓಕೆ, ಓನ್ಲಿ ಟು ದ aggrieved party. Okay, aggrieved party is entitled to receive the compensation if it arises naturally during the course of breach. But please remember, it will not be given for remote or indirect loss. That is said in section 73 of Contract Act and rule in Hadley versus Baxendale. Please write down this case law, Hadley versus Baxendale. You may get similar question. Yes, possibility of a similar question. Hadley versus Baxendale. You can write down related with ordinary damage. Yes, भाई पेन नहीं उल्टा पकड़ लिया, कैसे चलेगा? चलो, try to understand this. Hadley versus Baxendale. Okay, now the crankshaft of Pease flour mill had broken. Crankshaft, let us take some part of the machinery of the Pease flour mill has been broken. Okay, you know, machinery breakdown agide. He gives it to D, a common carrier. Carrier ಅಂತಂದ್ರೆ ಟ್ರಾನ್ಸ್ಪೋರ್ಟರ್. ಓಕೆ, ಟ್ರಾನ್ಸ್ಪೋರ್ಟರಿಗೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಏನಂತ, ಅದು ಬ್ರೋಕನ್ ಆಗಿದೆ ಅಲ್ಲ, ದಟ್ ಪಾರ್ಟ್ ಈಸ್ ಗಿವನ್ ಟು ದ ಕಾಮನ್ ಕ್ಯಾರಿಯರ್, ಪ್ರಾಮಿಸ್ ಟು ಡೆಲಿವರ್ ಇಟ್ ಟು ದ ಫೌಂಡ್ರಿ ಇನ್ 2 days. ವಾಟ್ ಡಸ್ ಹಿ ಸೇಸ್? ಐ ವಿಲ್ ಡೆಲಿವರ್, ದೇ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್ ಟು ಡೆಲಿವರ್ ಇಟ್ ಟು ಹಿಮ್ ಟು ದ ಫೌಂಡ್ರಿ in 2 days where the new shaft was to be made. So ಏನು ಮಾಡಿದ್ದಾರೆ? ಸಿಂಪಲ್, ನಮ್ಮದು ಮಿಲ್ದು ಏನೋ ಪಾರ್ಟ್ ಬ್ರೋಕನ್ ಆಗಿದೆ, so that we are giving it to carrier, please go and get it repaired, give it to the foundry, ಅಲ್ಲಿ ಅವ್ರು ರಿಪೇರ್ ಮಾಡಿಕೊಡ್ತಾರೆ within 2 days. Okay, so that has happened. For how many days? In 2 days, correct? The mill stopped working. ಅದು ಪಾರ್ಟ್ ಇಲ್ಲ, ಅದಕ್ಕೆ ಏನಾಗ್ತಾ ಇದೆ? Because that part is not there, the mill has stopped working. Delayed the delivery of the crankshaft, so the mill remained idle for another 5 days. Because that part was broken, what happened? The mill did not work. Mill work ಆಗ್ತಾ ಇಲ್ಲ. ಈಗ what is happening? That common carrier made a delay in the delivery. Crankshaft 2 days ನಲ್ಲಿ ಡೆಲಿವರ್ ಮಾಡಬೇಕಿತ್ತು, ಕರೆಕ್ಟ್? ಬಟ್ he took another 5 days. Another 5 days ಡಿಲೇ ಮಾಡಿದ್ದಾರೆ, ಅದರಿಂದ ಅವ್ರ ಮಿಲ್ ಇನ್ನೂ ಕೆಲಸ ಮಾಡಲಿಲ್ಲ, ಕರೆಕ್ಟ್? Mill will be closed for another 5 days. Now, P received the repaired crankshaft 7 days later than he would have otherwise did. ಅಂದ್ರೆ ಟೋಟಲಿ ಅವ್ನಿಗೆ ಎಷ್ಟು ದಿನದಲ್ಲಿ ವಾಪಸ್ ಬರಬೇಕಿತ್ತು, ಅದಕ್ಕಿಂತ 7 days late he has received. Okay, कितने दिन लेट आया है? 7 days late उसको crankshaft मिल रहा है. What was agreed? To that agreed date he has received the crankshaft 7 days later. Now P will keep quiet. P ಸುಮ್ಮನೆ ಇರ್ತಾರೆ. 7 days ಲೇಟ್ ತೊಗೊಂಡು ಬರ್ತಾ ಇದ್ದೀರಿ, 7 days your mill has stopped working. Now, tell me, will P keep quiet? Now, P is suing D, the carrier, for damages. Yes? Not only, he is asking damages for what? First listen to this. He is asking for the damages for the delay in delivering the broken part. Correct? He made a delay in delivering the broken part. So, he is asking damage for that one. Number one. He is also asking the damage for the loss of profits suffered by the mill for not having been worked. ನೀನು ಎಷ್ಟು ದಿನ ಅದು ತಗೊಂಡೋಗಿದೆಯಾ ಅಷ್ಟು ದಿನ ನಮ್ಮ ಮಿಲ್ ವರ್ಕ್ ಆಗಿಲ್ಲ. ವರ್ಕ್ ಆಗಿಲ್ಲ ಅಂತಂದರೆ ಯು ಹ್ಯಾವ್ ಲಾಸ್ಟ್ ದ ಪ್ರಾಫಿಟ್ಸ್ ಆಫ್ ದೋಸ್ ಮೆನಿ ಡೇಸ್. So he is asking two damages. Number one, he is asking damage for delay in doing the delivery. Second one, he is asking for the compensation for loss of profits during those extra 5 days. Okay? Now tell me, court will give both the damages or just give one damage? Did you get what two damages P is asking? Number one, delay in delivery. Second one, damages for mill remaining idle for another 5 days and loss of profit. So he is asking for these two things. Now because what I said, we are speaking about ordinary damage. Ordinary damage antandre enu, only which arises naturally will be given. Correct? So P, court held that P was entitled only to the ordinary damage and D was not liable for the loss of profits. So what will happen here is, please try to understand. Court nimige only first for the delay, avun delay madidnalla ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಏನು ಲಾಸ್ ಆಗುತ್ತೆ ಅದು ನಿಮಗೆ ಕೊಡ್ತಾರೆ. ಬಟ್ ಮಿಲ್ ವರ್ಕ್ ಮಾಡಲಿಲ್ಲ, 5 ಡೇಸ್ ತನಕ ನಿಮ್ಮ ಪ್ರಾಫಿಟ್ಸ್ ಲಾಸ್ ಆಯಿತು, ಯು ವಿಲ್ ನಾಟ್ ಬಿ ಅವಾರ್ಡೆಡ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಡ್ಯಾಮೇಜ್. ವೈ? Because did you inform the carrier? Did you inform the carrier? If you take this part, my mill will stop working. Did you tell it to the carrier? ಕ್ಯಾರಿಯರ್ ಅವ್ರಿಗೆ ಗೊತ್ತಾ ಇದು ಇದಕ್ಕೆ ಬೇಕು, ಅದಕ್ಕೆ ನಮ್ಮ ಮಿಲ್ ಸ್ಟಾಪ್ ಆಗುತ್ತೆ, ಪ್ರಾಫಿಟ್ ಬರಲ್ಲ. ಡಿಡ್ ದ ಕ್ಯಾರಿಯರ್ ನೋ ಅಬೌಟ್ ದಿಸ್? ನೋ. Because you have not informed the carrier about this, you cannot claim that damage. Are you clear? Okay na? Because information ಏನು ಕೊಟ್ಟಿದ್ರಿ? This is a broken article, please get it repaired. ಅಷ್ಟೇ ಹೇಳಿದ್ರಲ್ಲ, ಅವನು ಡಿಲೇ ಮಾಡಿದಾನೆ, ನಿಮ್ಗೆ ಅದು ಅಷ್ಟೇ you can claim. That's called as ordinary damage. Clear? Are you clear? You cannot claim for the loss of profits. Intade similar example you can get as case law. Please remember this. Okay? Now one more. A agrees to sell B. Now you have to answer this. Okay? A agrees to sell B bags of rice at 5,000 per bag. How much? 5,000. Delivery to be given after 2 months. On the date of delivery, price goes up to 5,500 per bag. Now, A is telling I will not deliver the bags. Arthaita? What is happening? 5,000 rupees bag ittu. Date of delivery time nalli 5,500 agittu. Correct? Now what has happened? On the due date he is telling there is a breach. Breach andre damages claim ಮಾಡಬಹುದು. Now there is a breach. He is refusing. I will not deliver anta ಹೇಳ್ತಾ ಇದ್ದಾನೆ. Okay, don't deliver. But you have to claim for the damages. Now how much damages can he recover? So how much he can recover? Because on that date ಅವನಿಗೆ ಏನಾದರೂ ರೈಸ್ ಬರ್ತಾ ಇತ್ತು ಅಂತಂದರೆ 500 rupees ಪ್ರಾಫಿಟ್ ಆಗ್ತಾ ಇತ್ತಾ? So he can claim 500 as ordinary damage arising directly from the breach. Correct? This is an arising, that loss occurred to him, that loss is damage is faced by that party naturally. So hence he can claim how much? 500 rupees. Are we clear? Yeah. Let me move to the second one then. Special damage. Ordinary damage, what it is? Normally arising in the ordinary course of business or due to the breach. Ordinary damage naturally occurring due to the breach in the usual course of business is called as ordinary breach. Okay? Next, special damage antandre same example togoli about the crankshaft. Okay? Come to the crankshaft. If suppose a carrier ಗೆ ನಾನು ಕ್ಲಿಯರ್ಲಿ ಹೇಳ್ಬಿಡ್ತಾ ಇದ್ರೆ, ಸಿ ನೀನು ಇದು ಬ್ರೋಕನ್ ಪಾರ್ಟ್ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದೆಯಾ, ಯು ಆರ್ ಟೇಕಿಂಗ್ ದಿಸ್ ಬ್ರೋಕನ್ ಪಾರ್ಟ್, ಸಿ ಬಿಕಾಸ್ ಯು ಆರ್ ಟೇಕಿಂಗ್ ದಿಸ್ ಮೈ ಮಿಲ್ ವಿಲ್ ನಾಟ್ ವರ್ಕ್ ಫಾರ್ ದೋಸ್ ಮೆನಿ ಡೇಸ್, ಹಿಂಗೆ ಹೇಳಿ ನಾನು ಕೊಡ್ತಾ ಇದ್ರೆ, ಇಫ್ ದೇರ್ ಇಸ್ ಅ ಡಿಲೇ ದೆನ್ ಐ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಫೇಸ್ ದ ಲಾಸ್. if I give notice like this to carrier, now can I claim both the losses? Same example I am continuing. Same example, in the previous example I just said, correct? Delay ಮಾಡ್ತಾ ಇದ್ದಾನೆ first. Second ಏನಾಗಿತ್ತು? He is asking that my mill stopped working and I lost the profit for 5 more extra days. Now, when giving that part to the carrier, I clearly tell to the carrier, see, you are taking this part with you. In ಎಷ್ಟು ದಿನ ನಿನ್ನ ಕಡೆ ಇರುತ್ತೆ ಅಷ್ಟು ದಿನ ನಾನು ಮಿಲ್ ಕೆಲಸ ಮಾಡಲ್ಲ and I will lose the profits. If I tell like this and give, can I claim the second loss also? Yes, you can. But this will be, see what happens here, very very important. What happens? Notice of the special circumstances affecting the contract. You gave the notice, these are the special circumstances, see this is happening, my mill will stop working. You gave the notice, correct? Then you will be entitled not only for the natural damages but also directly from the breach, but also for the special damages. Are you clear? Ordinary nu kelbodu, then you can also ask for special damages. Okay, so same example, we are reading it again, please listen. There is again a new twist in this. Answer the question, okay na? Yeah. So A delivered a machine to B, a common carrier, again conveyed A mill without delay, to be conveyed to A's mill without delay. A also informed that his mill stopped working for the want of machine. What did he tell? First take this part to the A's mill without delay ಮಾಡಬೇಡಿ, please take it ಅಂತ ಹೇಳಿದರು. Second point, what did he inform? My mill has stopped working because of that part. Okay na? B, unreasonably delayed the delivery of the machine. ತುಂಬಾ ಡಿಲೇ ಆಗಿದೆ. Okay, full late कर रहा है. उसके बाद क्या हुआ? In consequence, ಅದಂತೂ ಆಯಿತು. ಈಗ ಏನೇನು ಲಾಸ್ ಆಗ್ತಾ ಇದೆ? ನಂಬರ್ 1 ಡಿಲೇ, ಸೆಕೆಂಡ್ 1 mill not working, third one he also faced one more loss. What is that? He lost the contract with the government, because whatever it is, during that period he lost one government contract also. Now how much losses can he claim? Number 1, number 2, number 3, all 3, or 1 or 2 or 3? How many losses can he claim? Quickly. Number 1, loss due to delay. Number 2, mill stopped working, that profits. Number 3, he lost the contract with the government. How many losses can he claim? He can claim only number 1 and number 2. Why? Because he informed about the delay, he informed about the mill not working. So he can claim only these 2. Did he informed about any government contract to the carrier? No. So he cannot claim the third one, he can only claim for 1 and 2. Okay? This is special damage. Only if you give the notice of the special circumstances affecting the contract, you can claim those damages. Okay? Chalo. Are you clear with ordinary and special? Number 3, vindictive or exemplary damage. The name only says this damage is awarded only in 2 cases. Only in 2 cases you will get this damage. Number 1, breach of promise to marry. You promise somebody that you will marry someone and you break that promise. You break their heart. Then the other person is affected, correct? So that other person can ask you for the damages, and that's called vindictive or exemplary. Exemplary. See, nobody should promise and break the marriage, otherwise they are liable for the damages. Example set madlikke they are giving this, that's called as exemplary. Okay na? First one. Second one, wrongful dishonor of a check by the banker. ಇಲ್ಲಿ ಮತ್ತೆ 2 things ಇರುತ್ತೆ. Again 2 things ಹೋगा इसमें. Wrongful dishonor ಅಂತಂದ್ರೆ what is meant by wrongful dishonor? Wrongful dishonor means your check has your bank account has sufficient funds, but still due to the mistake by the banker your check bounces. Bounces means it is dishonored. What happens? Dishonored. Why? What happens? Suppose you are a very reputed person in the market, correct? You are a trading firm, any trading firm. What happens whenever your check bounces? Mentality in the society, what does they don't have funds in the bank? How did their check bounce? Correct? The reputation will get affected. And hence Hence, to avoid this, damages are given by the banker to the customer. That's called as vindictive or exemplary damage. Did you get it? It is given by whom? By banker to customer for the wrongful dishonor. Wrongly, there was sufficient funds, due to error the banker dishonored the check. Okay, but illi suppose if you are not a trading firm, you are just having a saving account. You are not a trading firm, you are just a, see now here let me tell this where it is, non-trader. Okay, this is about traders. Traders andre they trade regularly, they have some business transactions going on. Suppose I am a non-trader, I don't trade anything, but I also can give check sometimes, correct? But if my check gets dishonored, then damages recovered will be very less. I can recover very less damages because my reputation will not be affected that much, correct? So hence I cannot. But if I am able to prove my reputation also has been affected so much, then I will be able to claim the full damages. But I have to prove here. A non-trader has to prove that my reputation also has been affected to that extent. Only then I can claim the full damages. Trader idru, you will get the damages automatically. But non-trader idru, you will not be able to recover unless you prove it. Okay? Are you clear? See here, please. A businessman whose credit has suffered will get exemplary damage even if he has sustained no loss. Traders ige loss agilla antandrunu still they will get the damage. Okay, but non-traders cannot get heavy damages unless the damages are proved as special damages. You prove madbeku that there are special damages, only then you will be able to get it, not otherwise. Okay, that is said in Gibbons versus Westminster Bank. This is a case law. Gibbons versus Westminster Bank. Are you clear? Vindictive damages yavak kodtare? Only in two cases. Number 1, breach of marriage. Number 2, dishonor, wrongful dishonor of the check by the banker. You can write down the case law, Gibbons versus Westminster Bank. That's related with vindictive damage or wrongful dishonor of the check. Okay. Chalo. Nominal damage. What is meant by nominal damage? Nominal damage means, in fact, for you have not suffered. There is a breach of one contract was there. There is a breach of contract. You did not suffer any kind of damage. Okay? Namge anta pari enu loss agilla. Enu loss agilla namge. The contract was not performed, but due to the non-performance, I did not face any loss. But still, there was a breach alla. ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡಿನೂ ಮಾಡಿಲ್ಲ, ನನಗೆ ಏನೂ ಲಾಸ್ ಆಗಿರಲಿಕ್ಕಿಲ್ಲ, ಬಟ್ ನೀನು ಮಾಡಿಲ್ಲಲ್ಲ. ಸೊ ಫಾರ್ ದ್ಯಾಟ್ ಪರ್ಪಸ್, ಟು ಸೆಟ್ ಆ್ಯಂಡ್ ಟು ಗಿವ್ ದ ಜಸ್ಟಿಸ್ ದಟ್ ನೋಬಡಿ ಶುಡ್ break the contracts, some damages are being recovered and those damages are called as nominal damages. Okay, even though there is no loss, no real damage, but just to establish the right of decree that there is a court's order going on in the society, this damages are awarded. It might be even a rupee no irbodu, as a 1 rupee damage kodbeku, but kodbeku 10 paisa adru agbodu. See, now the 10 paisa not valid, but it is written like this in the law. Enadru kodbeku ashte. Are you clear? Next, damages for deterioration caused by delay. Deteriorate enagutte? Usually perishable goods or any goods which deteriorates. Anta cases nalli ಏನು? Suppose I was asked, I gave a truck or a carrier to transport 1 ton of apples, 10 tons of apples from here to, suppose from here to Chhattisgarh or from here to Madhya Pradesh. Now, suppose he makes a delay, on delay ಮಾಡ್ತಾ ಇದ್ದಾನೆ. Can I recover only ordinary damage or I can recover the loss? Both, because ಈಗ apples sale ಮಾಡ್ಲಿಕ್ಕೆ ಬರುತ್ತಾ? Delay ಮಾಡಿಬಿಟ್ರೆ apples will get rot. I cannot save it further. Correct? In this case, when the goods are in the nature of deterioration, delay in the deteriorate ಆಗುತ್ತೆ ಅಂತಂದ್ರೆ ಅಂತ ಕೇಸ್ನಲ್ಲಿ ನೋಟಿಸ್ ಕೊಡೋದು ಬೇಕಾಗಿಲ್ಲ. Even though without notice you will be able to recover the damages. Okay? So, damages can be recovered from the carrier even without notice, because ಫಿಸಿಕಲ್ ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ, ಬಟ್ ಆಲ್ಸೋ ಯು ವಿಲ್ ಲೂಸ್ ದ ಅಪಾರ್ಚುನಿಟಿ ಫಾರ್ ಸೇಲ್. ಮುಂದೆನೂ ನೀವು ಸೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಆ ಗೂಡ್ಸು ಕೆಟ್ಟೋಗುತ್ತೆ, ಮುಂದೆ ಸೇಲ್ ಮಾಡಲಿಕ್ಕೂ ಬರಲ್ಲ. ಸೊ ಯು ಕ್ಯಾನ್ ರಿಕವರ್ ಬೋತ್. ಓಕೆ, ವೆನ್ ದೆರ್ ಇಸ್ deterioration caused by delay in delivery. Now last one, prefixed damages. I think, yeah, prefixed damages means, let me check if I have given the differences between, yeah, I was searching for this. Okay, prefixed damages antandre, you have, before making the contract only you have fixed. Suppose ನೀನು ಯಾರಾದರೂ ಪರ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂದರೆ ಇಷ್ಟು ಡ್ಯಾಮೇಜಸ್ ಕೊಡಬೇಕು, that's called prefixed. Okay, so code ಏನು ಇಲ್ಲ, you have already made a contract clearly that in case there is a breach you have to pay this much as damage. That is called prefixed damage. Are you clear? Okay, now illi there are two words. There can be either liquidated damage, that's a reasonable amount, or there can be a penalty, that is too much higher amount. ನಿಮಗೆ ನಾರ್ಮಲಿ ಅಷ್ಟು ಡ್ಯಾಮೇಜ್ ಆಗಲ್ಲ, ಬಟ್ ಸ್ಟಿಲ್ ಯು ಹ್ಯಾವ್ ಫಿಕ್ಸ್ಡ್ ಆನ್ ಹೈಯರ್ ಅಮೌಂಟ್, ದಟ್ಸ್ ಕಾಲ್ಡ್ ಪೆನಾಲ್ಟಿ. ಅದಾದರೂ ಆಗಿರ್ಬೋದು. ಆರ್ ಯು ಹ್ಯಾವ್ ಫಿಕ್ಸ್ಡ್ ರೀಸನಬಲ್ ಅಮೌಂಟ್, ದಟ್ಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಲಿಕ್ವಿಡೇಟೆಡ್ ಡ್ಯಾಮೇಜಸ್. ಓಕೆ, ಬಟ್ ಸೆಕ್ಷನ್ 74 ಏನು ಹೇಳುತ್ತೆ, ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಇಫ್ ಸಮ್ ಇಸ್ ನೇಮ್ಡ್ ಇನ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಟು ಬಿ ಪೇಡ್ ಇನ್ ಕೇಸ್ ಆಫ್ ಬ್ರೀಚ್, the aggrieved party is entitled to receive from the party at fault a reasonable compensation not exceeding the amount so named. ಅಂತಂದರೆ ನಿಮಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ನಲ್ಲಿ ನೀವು ಎಷ್ಟು ಫಿಕ್ಸ್ ಮಾಡಿರ್ತೀರಿ. ಸಪೋಸ್ ಐ ಫಿಕ್ಸ್ಡ್ ದಟ್ ಇನ್ ಕೇಸ್ ಆಫ್ ಬ್ರೀಚ್ ಯು ಹ್ಯಾವ್ ಟು ಪೇ ಮಿ 1 lakh rupees, ಬಟ್ ನನಗೆ ಆ್ಯಕ್ಚುವಲ್ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ 2 lakh rupees. ನೌ ಟೆಲ್ ಮಿ ಹೌ ಮಚ್ ಕ್ಯಾನ್ ಐ ರಿಕವರ್? 2 lakhs or 1 lakh? In the contract we have fixed, if there is a breach I will be receiving 1 lakh rupees as damages. Now if the actual damage occurred to you is 2 lakhs, how much can you recover? 1 lakh only. That is said in section 74. Okay, you will not be able to recover any compensation exceeding the amount so named in the contract. Okay, clear? Suppose you tell me, ನನಗೆ I said that damages could be recovered is 1 lakh, but ನನಗೆ actual loss ಆಗಿರೋದು only 70,000. How much can I recover? 70,000 or 1 lakh? No, I could recover only 70,000. See, check for the answer. If the penalty provided by the contract is 1 lakh and actual loss is 70,000, how much will you be recovering? You said 1 lakh, correct? But no, we will be recovering 70,000 only as damages, the amount of actual loss and not the amount stipulated. ಬರ್ದಿರ್ಬೋದು, ಬಟ್ ನಿಮ್ಗೆ ಆ್ಯಕ್ಚುಲ್ ಲಾಸ್ ಎಷ್ಟಿರುತ್ತೆ ಅಷ್ಟೇ ನಿಮಗೆ ಸಿಗುತ್ತೆ, ಜಾಸ್ತಿ ಸಿಗಲ್ಲ. ಪ್ಲೀಸ್ ರಿಮೆಂಬರ್ ದಿಸ್. ಬಟ್ ಇಫ್ ದ ಲಾಸ್ ಇಸ್ ಸೇ 1,50,000, ಅವಾಗ ಎಷ್ಟು ಸಿಗುತ್ತೆ ನಿಮಗೆ? ಓನ್ಲಿ 1 lakh. ದಿಸ್ ಇಸ್ ಸೆಕ್ಷನ್ 74. ಆರ್ ಯು ಕ್ಲಿಯರ್? ಓಕೆ, ನಾವು ನೆಕ್ಸ್ಟ್ ಇಸ್, ದಟ್ ಈಸ್ ಅದು ರೀಸನ್ ಏನು, ಇಮ್ಮಿಡಿಯೇಟ್ಲಿ ಐ ವಿಲ್ ಟೆಲ್ ದ ನೆಕ್ಸ್ಟ್. ಮ್ಯಾಮ್ ದೆನ್ ವೈ ವಿ ಮೇಕ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್? ನೋ, 1 lakh ಅಂತ ಯಾಕೆ ಬರೀಬೇಕು? ಎಷ್ಟು ಲಾಸ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಬರೆದ್ರೆ ಆಯ್ತಲ್ಲ, ಕರೆಕ್ಟ್? ದಟ್ ವಿ ವಿಲ್ ಸಿ. ಐ ವಿಲ್ ಆನ್ಸರ್ ದಟ್ ಕ್ವೆಶ್ಚನ್ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ಪಾರ್ಟ್. Now tell me, X promised Y. You have to answer this question quickly. X promised Y, a priest, to pay 10,000 as charity. 10,000 ಕೊಡ್ತಾರೆ ನಿಮಗೆ. The priest on X's promise incurred certain liabilities towards repairing of the temple. On ಕೊಡ್ತೀನಿ ಅಂದದಕ್ಕೆ you have already started the repairing of a temple to the extent of 7,500. ನೀವು ರಿಪೇರಿ ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದೀರಿ. Now tell me, how much can you recover from X? If suppose he is not giving 10,000 now, then you can recover. How much you can recover? Only to the extent of 7,500. The actual loss ನಿಮಗೆ ಎಷ್ಟಾಗಿದೆ ಅಷ್ಟೇ ನೀವು ರಿಕವರ್ ಮಾಡಲಿಕ್ಕೆ ಬರುತ್ತೆ. ಓಕೆ, ಕ್ಲಿಯರ್? ಆರ್ ಯು ಡನ್? ಸೊ ವಾಟ್ ಆರ್ ದ 6 types of damages we have seen? Number 1, ordinary. Number 2, ordinary ಅಂತಂದ್ರೆ arising naturally. Okay, here special damages cannot be claimed. Here special damages means you have to give notice. If notice is given, the special circumstances affecting the contract due to breach can also be. Next is vindictive. This is awarded in 2 cases. Marriage, number 1. wrongful dishonor of the check. Okay, here again trader, non-trader. Okay, number 4. Huh? Nominal. What is meant by nominal? What's meant by nominal? Even though no loss has occurred to you, but still you have to pay something just to establish the right of decree. That's called nominal. Next one. Deterioration of delay. Losses caused due to deterioration. Even without notice, you will be able to claim the damages if there is deterioration caused in the goods due to delay. Number 6, prefixed damages. What are the prefixed damages? The damages which are already fixed in the contract to be payable in case of breach is called as prefixed. It can be either liquidated damage or penalty. Liquidated damages means a reasonable amount. Penalty means a higher amount. Now I am defining what is liquidated damages and penalty in detail in the next part. Okay, shall I move on to the next part, or do you have any doubts still here? If you have any doubts, then we will wait, otherwise I will start with section 74. Shall I? See, both are damages only. Penalty is also a damage, liquidated damage is also a damage. Both are payable only in case of breach. Breach idre matra iveredu barutte, illandre eradu baralla. Okay na? Okay? Only in case of breach both are payable. But suppose, number 1, the sum payable is so large. How it is? The sum payable is large. So large, so far in excess of the probable damage. ನಿಮ್ಗೆ ಎಷ್ಟು actual damage ಆಗಬಹುದು ಅದಕ್ಕಿಂತ ತುಂಬಾ large amount ಇದೆ ಅಂತಂದ್ರೆ that's regarded as penalty. Okay? ನಿಮ್ಗೆ actual loss ಆಗಕ್ಕಿಂತ ಜಾಸ್ತಿ extraordinary amount if you have kept so far, so large, then it is called as penalty. What is liquidated damage? Further in some of the where a sum is expressed to be payable on a certain date and a further sum in the event of default being made. So suppose you are fixed illitana madila, suppose on this till this particular date, if you don't make the delivery, then you have to pay this much sum. Then otherwise if ee date cross admelenu ನೀವು ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತಂದ್ರೆ you have to pay further more sum. ಈ extra amount ಏನಿರುತ್ತಲ್ಲ, that is penalty, and this amount will be liquidated damages. The later sum is regarded, just because you are making a delay in the payment, you are taking this extra amount, so that will be your penalty, but this is due to your actual loss and hence it is liquidated damages. ನೀವು ನಿಮ್ಮ ಕಾಂಟ್ರಾಕ್ಟ್ನಲ್ಲಿ ಏನಾದರೂ ಬರ್ಕೊಳ್ರಿ, ಅದು ಪೆನಾಲ್ಟಿ ಆದರೂ ಅನ್ರಿ or liquidated damages ಆದರೂ ಅನ್ರಿ. Yeah, you either name it as liquidated damage or name it as penalty, nothing matters. The court's decision is final. Court ಏನನ್ನತ್ತೆ? See, expressions used by the parties is not final. What is final? Court will find out whether the sum fixed in the contract is in truth penalty or liquidated damages. ನೀವು liquidated damages ಅಂದ್ರೆ ಏನು? What is meant by liquidated damages? The actual loss faced by you, the actual damage, a reasonable damage faced by you. The reasonable amount is liquidated damage, the extraordinary amount is penalty. ನೀವು ಬರ್ದಿರೋದು, suppose in the contract you write it as liquidated damages, use the word liquidated damages but writing extraordinary amount. So if you do like this, then court will tell it is liquidated damage only, now give this much. No, court will find out in reality what it is. Okay, so if the sum amount is fixed is extraordinary, then court will treat it as penalty. If it is normal, then it will treat as liquidated damages. At court decide ಮಾಡುತ್ತೆ, ನೀವು decide ಮಾಡೋದಲ್ಲ. Even though you would have written it as anything, the court will say if it is a normal amount, then it will take it as liquidated damage. If it is an extraordinary amount, then it will treat it as penalty. Last one, the penalty. Why is penalty? Only to create terror in the offending minds of the offending party. ಒಂದು ಭಯ ಇರಬೇಕಲ್ಲ, only to create that terror in the offending party that we should not break, otherwise we have to pay so much. But liquidated damage is not like that. Liquidated damage is a real pre-estimate of the damage. ನಿಮ್ಗೆ real ಎಷ್ಟು ಡ್ಯಾಮೇಜ್ ಆಗ್ಬಹುದು ಅಂತ genuine estimation. Okay? English law makes a difference between liquidated damage and penalty, but no such distinction is followed in India. India ನಲ್ಲಿ ಹಂಗೇನೂ ಇಲ್ಲ. ನಿಮ್ಗೆ actual loss ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟೇ ಸಿಗುತ್ತೆ, not more. Okay? Are you clear? But there is an exception. If any bond is given to central government and state government, then whatever is mentioned, that sum only will be payable. Avaga penalty na, liquidated damages, that does not matter. Whatever the amount is paid, return, that will be payable. Where? Only when there are bonds of central and state government. Yeah, governments, no, they will take whatever they want. Correct? Avagalli reasonable idena illa, that all does not matter. Chalo, quickly examples. Now tell me answers. Then we will move on to the next remedies. Okay. So, yeah, A contracts with B that if A practices as a surgeon in Kolkata, he will pay 50,000. Okay. Now, if A practices as a surgeon at Kolkata, B is entitled to take such compensation of 50,000 is payable. Correct? Yeah. So, that's the first one. A borrows 10,000 from B and gives him a bond of 20,000 payable by 5 yearly installments of 4,000 with a stipulation, in default of payment the whole sum shall become due. This is a stipulation by way of penalty. What is it telling? If you fail to pay any installment, then I will be covering the full amount again. That's a penalty only, no? Remaining balance togobekashte. But he is telling I will recover the full amount. That is again a penalty. Okay, now here A undertakes to repay a loan of 10,000 by equal monthly installments with the stipulation that in default of any installment, the whole sum shall become due. This stipulation is not by way of penalty and the contract may be enforced according to its term. Because it involved a bond here. It involved a bond, it was penalty. Otherwise, it is normally treated not an penalty. Ill loan ide, just a normal loan. If you make a default, then they will be able to recover the full amount. Then it's not a penalty, it is enforceable according to the terms of contract. Okay? So, moving on to the next topic. Are we clear? So, what all we have studied till here? What all? What is breach? Types of breach, effects of breach. Next, we have studied types of damages. Now, other new damages and through you can claim. आप damages तो claim कर ही सकते हो. उसके अलावा, these are also the remedies you have in the contract. What are the remedies we have? First one, rescission of contract. What's meant by rescission? Rescission means cancel. So, if the contract is broken by one party, the other party can also treat the contract as cancelled, rescinded. He is also free from the obligations, duties. Correct? If he breaks it, I am also free from all the duties and I also can claim for the compensation. Correct? Yeah, that's only called rescission. Rescission means the other party has a right to cancel the contract and ask for the compensation. See, look at the example. A promises B to deliver 50 bags of cement on a certain day. B agrees to pay the amount on receipt of goods. Okay, fine. Goods barley, I will give the payment. A failed to deliver the cement on appointed day. B is also discharged from paying the price. In goods se kotta illa andre nan amount kortina. No alla? Chalo, that's the first one. What is that? First remedy is rescission of contract. Second one, quantum merit. Quantum merit means what? Quantity of merit taken by you. Remember like this. Quantity of merit or benefit taken by you. Accordingly, you have to make the payment. Okay, na? So, let me define it. Very important. What's meant by the quantum merit? Suppose one party has rendered service to the another party, which indicates an understanding between them. Suppose, I'll first give the example. He is my regular auto driver. Okay. So, whenever I call him, he comes. Now, suppose I am I'm traveling some 10 kilometers with that auto person. I didn't speak how much he will take. I've asked nothing. I just called him, he came, I sat and I went away to my destination. Now, can I just tell, because no remuneration was fixed, ನಾವೇನು ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲಲ್ಲ, I will not make the payment. Can I tell like this after taking the service? Is it possible? Normal auto person only. Why my regular driver? Normal, on the way auto is there, you sat in the auto, you said drop me off to that particular place. Okay, I said drop me off to Rajaji Nagar, Julai Nagar, correct? So I said drop me to Julai Nagar. Now he drops me to Julai Nagar. I get down at my destination. Now I will tell him I will not make the payment because we did not fix know how much to pay. So I will not pay you. Can I now go? Aram se tata bye bye. The auto person will keep quiet. Law ನಲ್ಲಿ ಏನಾಗುತ್ತೆ ಆಮೇಲೆ ಆಗುತ್ತೆ. First he will start doing drama, correct? Yeah, but law also, even though the remuneration was not decided, even though nothing was decided, he can still go to the court and sue you and recover the amount from you. Okay, how? Because of this quantum merit. What happens? Even though no remuneration has been fixed, but law will infer and promise to pay. Law will force you to pay. Make a promise to pay. That's called as quantum merit. When you have taken service from another party because of the understanding between them, and you have not fixed the remuneration, but still law will infer and promise to pay. And that's called as, andre quantity of benefit I have taken, accordingly I have to make the payment. Are you clear? So as much the party doing the service has deserved, that much you have to pay. Okay, but only two conditions. If was a case where the party injured by the breach had a time of breach done part, but not all of the work which is bound to do under the contract, seeks to be compensated for the value of work done. Antandre, suppose on half the way, if you has not dropped you till full point, but still wherever you have traveled to, or wherever did you get down, you have to give the compensation till that part. If the part of the work is done, you have to pay for the part of the work, even if the whole of the work is not done. Okay, but he can deduct, suppose I have given a contract to build a complete furniture, but half of the furniture work is done, half of the one I am cancelling him. I have to make payment for the half of the work done by him or not? At least half furniture he has done, Allah. I have to make payment for the half of the work. But what benefit I will have is, I can deduct some amount telling that it is a bad work. Ad nan madlik barutte. Okay na? Are you clear? Chalo. It is available only if the original contract has been cancelled, and number 2, the party not in default. Auto driver not in default alla, he can bring a case against me. Okay, avag matra. So what is the main basic object of quantum merit? The main basic principle ide. So recompensate the party for the value of work which he has done. Okay, so damages are compensatory in nature, but quantum merit is restitutory. Damages usually ಯಾಕೆ ಕೊಡ್ತೀವಿ? ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಬ್ರೀಚ್ ಮಾಡಿದಾಗ ಕೊಡ್ತೀವಿ. ಇಲ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಇರಲಿಲ್ಲ, but still you have to pay. Okay na? So reasonable compensation will be awarded if there is at all there is implication. Now, answer this. A person orders 12 bottles of whiskey. Okay, now 12 bottles plus he also receives 2 bottles of brandy. Nimge 12 bottles wine, you asked only for 12 bottles of wines. He gave you 12 bottles of wine, but he also gave 2 more bottles of brandy. You accept it. Hey, extra 2 bottles. Then now that shopkeeper tells you to make the payment for extra 2 bottles of brandy, are you liable to pay or not? You pay ಮಾಡಬೇಕಾ ಮಾಡಬಾರ್ದಾ? If you take the benefit, then you have to pay. That's the rule. Okay, so purchaser must pay for the brandy. Clear? Otherwise don't take it. No, we don't want to. Ask clearly, free na, then take it, not otherwise. Chalo. So claim for quantum merit arises in the following cases. Quantum merit evag barutte anta, we are just summarizing it once. So what are those? Let us summarize it quickly, then move for the next ones. Okay, number 1, where an agreement is discovered to be void, when a contract becomes void. So quantum merit antandre, suppose the painter has done half of the work or a book is half written, then something happens. So whatever happened, suppose that rent agreement, do you remember that rent agreement? 12 months rent was paid in advance, 7 months fire occurred in the factory, but 7 months you used the go down ala, pay for 7 months. If advance was not given, pay for 7 months, correct? How much benefit you have taken, you have to pay for that much. Even though we could not give it you for 12 months, nam contract agirbodu, but because there was a fire, the contract became void, correct? But you use the go down for 7 months, pay for 7 months. Clear? That's number one. Second one, you are doing it without any intention to do it gratuitously. You are not doing for gratitude. Bare thank you ಹೇಳಲಿಕ್ಕೆ ಅವ್ನು ನಂಗೆ ಡ್ರಾಪ್ ಮಾಡ್ತಾ ಇಲ್ಲ. Gratitude. Oh, I am so happy today, I will drop you. No, Allah. He is doing it for money only. Correct? Next, there is express or implied contract, but there is no agreement for remuneration. Now, payment fix ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ, but contract ಇದೆ. Okay? Next, when one party abandons or refuses to perform the contract, drop I am refusing to pay Allah, I am refusing. So where a contract is divisible and party not in default has enjoyed the benefit, I have taken the benefit means I have to pay. But yes, if there is a lump sum amount, like I said in the case of furniture, the other party can make a deduction for bad work. Nan bad working deduct marlik barutte. Okay, now quickly answer these two questions, then we will move on. X wrongfully revoked. X wrongfully revoked. Listen to this. Y's his agent authority before Y could complete his duties. You appointed an agent, and before he could complete, you have broken again. You have removed him from the agency. But Y can recover the amount for the work done by him, even though he has not completed full his duties, but whatever duties he has performed, he can claim the amount for that work. Okay, clear? Now next one. Example, A agrees to deliver 100 bales of cotton to B at a price of 1000 per bale. Okay, now the cotton bales were to be delivered in 2 installments of 50 each. 50-50 nal deliver ಮಾಡಿ ಅಂತ ಹೇಳಿದಿರಿ. A delivered first installment but failed to supply the second. First installment ನೀವು ತಗೊಂಡಿದ್ದೀರಿ, ಯೂಸ್ ಮಾಡಿದ್ದೀರಿ, ಸೆಕೆಂಡ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ನಿಮಗೆ ಬಂದಿಲ್ಲ, ಸೊ ಯು ಶುಡ್ ಪೇ ಫಾರ್ ದ ಫಸ್ಟ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಆರ್ ನಾಟ್? Yes, you should, because you have taken half, pay for the half. Even the second was not delivered, but you used half Allah, so pay for the half. Are we clear? Yeah, okay. So that is quantum merit. First is rescission of contract. First remedy is rescission. You can cancel the contract and claim for the compensation. Number 2, quantum merit. So whatever quantity of benefit is taken by you, pay for that amount. Number 3, suit for specific performance. Nimge whatever amount of damages is given to you, that is not sufficient. That is not sufficient. What you promised, please do that only. I don't want money, I don't want compensation, I want what? Performance. Whatever you have promised, please do that. I want that. Okay, that's called suit for specific performance. When how much ever damage is given to you, that is not adequate enough, that is not sufficient enough. See, where damages is not an adequate remedy, then the court will decide and gives a direction for specific performance. For example, let me give you an example. Suppose there is a painting, a unique painting. Okay, there is a unique painting and you want it for rupees 50,000. Deal was done. Okay, now he is not ready to give you the painting. Now what happens? Adhe painting e beku. You can ask, go to the court and ask for the performance only. Painting e kelbodu. Nang damages veda, I want that painting only. That's called suit for specific performance. Clear? But it will be decided by court at its discretion. Clear? Next one, suit for injunction. Again, the questions come from this. Injunction order means stopping somebody from doing. Injunction means you are restraining the person from exceeding the terms of the contract. When he is negating the terms of contract. Andre, suppose I made a contract with, suppose let us say Shraddha Kapoor. Okay, for advertising or for my brand. Okay, and but for a period of 1 month, I can afford that much only, I guess. So now 1 month we have asked her to stay with us, with our brand. And we have also made an agreement that within that month, she should not go anywhere else and she should not advertise anywhere else. Okay, within that month. Suppose she goes somewhere within that month, after 10 days only she is again doing some advertisements with the other brands, then what rights will I have? I can bring a suit for injunction. What is meant by that? I can stop her from going with the other brands because she is negating the terms of my contract. Correct? That's called suit for injunction. Are you clear? Yeah? Chalo. So what we are doing, by court we are getting an order, that's called injunction order, and we are restraining them from doing what they promised not to do. They promised they will not go with the other brands, but they are still going, so we can stop them. That's only, see, a film star agreed for 1 year, but they started going to other producers, then they can be stopped by injunction. Again, a singer, they will perform for 2 months, but they started going to somewhere else or they should not perform, then you can stop from them going from somewhere else. So now the last one. So what we have discussed: rescission, quantum merit, specific performance and injunction. Now last section 75, party rightfully residing contract entitled to compensation. Very easy. Suppose you make the breach, you don't deliver 100 bags of rice to me, then what I can do? I can cancel the contract and ask for compensation, correct? What rights will I have if the other party breaks the contract? Very simple. I have the right to cancel and claim for the compensation. That is only said in section 75. I have rightfully cancelled the contract, then I am entitled to compensation for damages which I have faced through the non-fulfillment. That's only said there. Listen to the example. A singer contracts with B, the manager of the theatre, to sing at his theatre for 2 nights in every week during the next 2 months. This example comes many a times. B engages to pay her 10,000 for each night's performance. Okay. On 6th night, A willfully absents himself from the theatre. Now, what can we do? If I said that a singer, this question, I think it has come in the last paper or something. Yeah. So, what was asked here? There was a contract that you should perform for 2 nights in every week and for the next 2 months. But on 6th night, if he is not coming, then what will happen? What right B gets? He is failing to perform. A is failing to perform, then B gets the right to cancel or not. Whenever any party fails to perform, then the other parties immediately get the right to cancel the contract. Okay, now, so here B can cancel the contract. B not only can cancel but also claim for compensation for the damage. Okay, very easy. What B gets the right? B can cancel the contract and claim for the compensation. That's the answer. Okay, clear? So this is about our breach and its remedies. What is meant by breach? Then what are the remedies we have? Okay, clear? Please go through the descriptive questions what are given in the module. We will discuss some of the questions later. Okay, in the next class or after we complete the units, we will discuss all those question and answers. But I am asking you to go and solve them today. Okay, please answer all the unit 5 questions today in the manner provisions, analysis and conclusion. If you have any doubts, we will discuss this later. Okay, see you. Thank you so much.